title of today's lecture is the role of the expert witness in environmental cases. The role of the expert witness. Let's review how legal proceeding works. So you have one person who basically have a dispute between two parties. We call one party the plaintiff. The other party is the defendant. They have a dispute. How do they settle their dispute? In the old days, one would just bonk the other one on the head with a hammer. Nowadays, we discovered language, using our words, having contracts, other sorts of means of communication, and dispute resolution. And now, when two parties have a dispute, they go to some third-party adjudicator or a judge. So they go to a judge. When they go to a judge, and remember this is for this is an environmental dispute. Is it just going to be he said, she said? Is it just going to be plaintiff said, defendant said? In your hearings, did you just sit there and just say, I believe this is my opinion is worth as much as your opinion, and then that's how the adjudicators settled it? Who's got the nicer opinion? So, usually have evidence. Both parties provide evidence. We have evidence. In addition to their claims. But what's special is that there's all sorts of evidence, right? So you can have pictures, you can have videos, you can have contracts. There's a special kind of evidence called an expert witness. An expert witness is different than a regular witness. So you have contracts, you have photographs, you have normal witnesses, and then you have expert witnesses. This applies to this side too. What could be the difference between a witness and an expert witness? Yes?
An expert witness would be someone with relevant education and training.
Yeah. An expert witness has specific scientific or technical knowledge. What a normal witness, they just say what I've heard, what I've seen. The expert says what I know. The expert is brought on for their special opinion. You bring on experts because you trust their opinion. Any other witness, their opinion counts as 0. Who determines who is an expert witness? There is, when you go to trial, if you want to bring on an expert witness, there is something called the qualification process. The expert has to go through a qualification process. This is basically a mini trial with the two lawyers and the judge. And the expert witness sits down and they have a trial over whether this expert witness is truly an expert. The expert brings on his CV, they talk about his publications, they talk about his other record, his other appearances in court, his other background, whether it's relevant or not. And then they determine whether this guy is a true expert. Another issue, when it comes to expert witnesses, the person who wants to bring on the expert, they want, I'm going to call this the litigator. Litigator wants broad expertise. The opposite party, other side, wants narrow specialization. Bring on a witness. You say this, why would you want an expert witness who's got a broad base of knowledge? Why would you want an expert who's like an expert on multiple fields? Yes?
Because environmental issues are generally holistic issues, like they're not, like they don't exist in a vacuum, they have economic impacts and like even within the field of environmental science, we have a whole bunch of sub-issues, so you need someone that understands how they interact with each other.
Yeah. So that's one reason. There's multiple things at play. Yes?
A general expert would be more useful to the opposing party because they could then kind of get them to use their other knowledge to make an argument other than the one that the plaintiff wants.
Yes. So the more broad-based their knowledge, the harder it is to argue against them from one person on the other side.
No,
Not-
that's what I was trying to say.
Now you're trying to say, so what's that?
I'm just it's saying, so if you're the litigator, you want
Yeah.
someone with like a specific expertise, because you know that what they're going to say is going to prove your point. But if you're the opposing party, you want them to have a broader knowledge, so you could kind of use another discipline of their expertise to kind of prove an alternative argument.
So I'm making the opposite claim here, that the litigator wants broad-based knowledge.
Oh. I wrote that down on them.
Yes?
Like providing supporting evidence and with broad range of knowledge would be able to testify that a more broad range of evidence is valid, rather than someone who's sort of very specific and able to be an expert for a wide range of issues. So they're less useful in sort of being a witness and testifying for the performance of evidence.
So to narrow down what you're saying, the narrower the specialization, the harder it is to, the smaller their contribution is going to be to the preponderance of evidence. Excellent. Yes. Any other ideas? Here's one more idea. So there's no limit on how many experts you can bring on legally. But when you're litigating, it still costs money to bring on experts. Oftentimes you have to pay these experts to come by. And the fewer experts you can bring on, the less you have to pay them. So there's monetary aspect as well. On the other hand, the defense is trying to make your life more difficult. So they say, no, if you want to make this claim, it has to be this one specific narrow guy. And you're going to make more claims, you got to bring on more guys, which is going to cost your team more money. So there's some legal strategizing that happens. You should also expect this qualification process, just this qualification process. There's just three of you in a room. They're sometimes called a deposition, where it's going to be the lawyers on both sides and the judge, or maybe not even the judge, someone representing the judge, and a tape recorder. And they'll be asking you it could be personal questions, it could be technical questions, it could be long-winded, complicated questions. And it can go on. There's no limit for how long they can ask you questions. So it can be a grueling process. One economist I know who did this once said the best advice he got was that during this process, when they're recording and typing everything, all your answers, they never write down how long you took to think up an answer. So if you feel that you're being pressed, you don't have to rush to give an answer. Just slow down, collect your thoughts. It's not going to go on the record that you took 5 minutes to come up with an answer. But if you make a mistake in giving an answer, then they'll go back to your record and say, hey, you made contradictory claims here, you're an idiot. Then they'll kick you off the case. You guys, as environmental science majors, you will be probably asked at one point or another to, if you go into this field, you will be asked to testify in court as an expert. And this is going to be part of the process. So, there are several different roles that expert witnesses can take. So, first is determining facts. Was there a contamination? Or was that swamp always there? How long has the contamination been there? What could have been the scientific cause of this contamination? Where did it come from? What will be the scientific impacts of this contamination? Where is it going to go? Is it possible that this contamination could have, the effects could have worn out over time due to weathering? What does what say? Determining facts. Remember the rules. Another thing that they can do is that they can just be advisors to the litigator, but they won't have to testify in court. You are just, you're part of the legal staff, basically. You bring on, the legal staff says, hey, you're going to be, they're going to be arguing such and such. What should we do? And then you as the advisor say, oh, this is going to be, you're going to need a marine biologist to sort this out, or a seagull expert to sort that out. That's an advisory role. You get paid to do that. As economists, one job you'll be doing a lot is estimating damages. When you're estimating damages, you have to be really careful in distinguishing between different costs. You got to make sure that you're accounting for the correct discount rate, inflation. You're not double counting. That's a big issue. When you're a non-economist, you'll count all sorts of other things twice you won't even realize. So economists come by and they estimate damages, just the monetary value. One thing you should be aware of is that there's a distinction between scientific cause and legal cause. There's a distinction between scientific cause and legal cause. Scientifically, it could be that the cause of a contamination was the nuclear plants erupting or melting down, whatever. But legally, they might not be liable for any damages. So your job as an expert witness is to just determine scientific cause and then leave it to the lawyers to figure out what the legal cause is. And a big source of problems for expert witnesses in discrediting themselves is that they confuse scientific and legal causes, and then this leads to contradictions, and then this leads to them being discredited, and they're wasting everyone's time and money. Finally, one thing expert advisors do is that they fashion remedies. They fashion remedies. There's been a contamination, scientifically proven. There's been a scientific establishment of the cause. There's been also a legal establishment of the cause. We figured out who's liable, who's owed damages. Scientist comes along and says, what is feasible? One case could be you contaminated an area. It might be 1,000 years before the contamination is free. The area is contamination free. So you would come in as the expert witness, say this contamination is going to last for 1,000 years. This place is going to be unhospitable, you can't build property on there, you can't do farmland on here. This is going to be dead areas, so they're going to need new lands. You're going to give them, you have to compensate them for the whole value of the land. Or you come by and say, no, this is going to be a pretty cheap cleanup. If they clean it up and then they put a cap on their sewage pipes, then that should be enough, an injunction. Yeah?
So if they destroy areas, you're gonna pay for it and then give them new land so they can destroy it.
Not necessarily. So you would just say what the remedy is. So you talk about what the possible remedies are. So if your land has been destroyed for 1,000 years, as the expert witness, you come by and say this land has been destroyed for 1,000 years. It's no use just putting a plug onto whatever is causing the contamination. You need to compensate them monetarily also for the entire value of the land. You've basically taken over their land.
Compensating people who polluted?
You're compensating the people who have been polluted. So the person who did the polluting has to compensate the people who have been polluted. Questions? There are basically two phases during trial. There's something called the examination in chief. The examination in chief is that the expert witness writes up a report, typically in Q&A format, and then submits it to the court. And just as a side note, when we say the court, typically this is synonymous with the judge. People like to confuse the court with like the courtroom. No, the court is the judge. That's just a little word trivia. But you write up your examination in chief, you submit it to the court. It can be used in full, it can be used in part, it can be used for you, it can be used against you. The court might not even read it when they're making their judgment. It's just part of the record. That's phase one. Phase two is the juicy bit, which is called cross-examination. Cross-examination. Cross-examination is you sit on the trial stand, and first the person who hired you asks you some questions to explain your credentials, explain your scientific findings, and then the other side gets up, and then they question your credentials. They question your motives, they question your expertise, they question your scientific findings. This can be even more grueling than the qualification process. There was a case where 17 different teams of lawyers examined one witness. During the O.J. Simpson trial, they were trying to introduce, it was going to be one of the early cases where they were bringing on DNA evidence. Have you guys heard of the O.J. Simpson trial? Not? Okay, so you guys are right. So they were one of the first, that was one of the first trials, high-profile trial on TV, that they tried to introduce DNA evidence. And they had a doctor there, and or some sort of scientist. He was there to talk about DNA evidence. And then they talked about the OJ's defense team. They came up, and they spent many, many hours questioning everything about the defense because they had an entire team of scientists who had gone through every little piece of thing in that trial. And they tired the guy out and it was bizarre. The video is up online, and it's very interesting to watch. How long it lasts, how many different questions they ask. They'll ask the same question in different ways to try to trip you up. The guy who was on OJ's defense team questioning and casting doubt on the DNA evidence went on to found the Innocence Project a little while later. So he really knew his DNA evidence inside and out. Let's talk about some challenges. So you can always tell that there's going to be some sort of problems. The first thing is conflict of interest. If you are brought on as an expert witness and it's found that you have some sort of personal connection with the person that you're trying to defend objectively and fairly, the defense or the other side can use that against you to discredit your testimony. This happens. How does this happen? Is because there are professional expert witnesses. There are entire firms focusing on litigation consulting. And they have economists, they have environmental scientists, they have all sorts of other experts in different fields that they pay salaries and wages and contracts to. And then they become established as experts. These companies have been around for many decades. And over time, you get to know the other companies, you get to know the lawyers, you get to know everyone. And if it's come to the attention that you've developed a personal relationship with anyone, then that will cast doubt on your expert's credibility. Another issue would be because each side is allowed to bring on their own expert, and we talked about how costs are subjective, goods are subjective, a lot of reality is subjective. Different experts on the same topic can have divergent views. One says, it's obvious that the contamination was brought on in the last month. The other says, no, the contamination scientifically has been there for many years. Who do you believe? Then you gotta bring in other experts and you gotta bring in other lawyers to question and advise and strategize. So that's another complication. There's also the issue of because you're going to be on trial for many hours, it can be grueling, you can get confused, you'll slip up, and you might offer contradictory evidence. Or, even worse, if you're a scientist, this happens a lot with scientists, they'll be on stand and they'll say, yes, according to my models, it's obvious that this kind of contamination will lead to these kinds of problems and will last for 1,000 years. The defense will get up and say, that's a very interesting analysis. I just found your own published research on this very topic from 10 years ago, where you said that this kind of contamination is no big deal and it evaporates on its own within 6 months. They'll use your own words against you. Not from that trial, but from outside of the trial. That's an issue too. Let's just go back and remind ourselves the difference between liability and damages. Liability means whose fault it is. As an expert, you can be brought on to establish whose fault it is. Where is the source coming from? You can also be brought on to talk about damages. how much were the damages? Is it okay to stop the damages? Is it okay to, is it possible to reverse the damages? Do not confuse liability and damages, or else the lawyers will eat you up. They will devour you, and you'll be embarrassed in front of a jury of your peers. Do you want to be embarrassed in front of a jury of your peers? No? So don't mix up liability and damages. Let's just end with two court cases. One was called FARE1040 versus the government of British Columbia. FARE1040 is a forcing company. One thing led to another. They set a large part of the British government's property in the forest on fire. They said, oopsie. The British Columbia government sued them for damages, and then the question was, how much damages did they do? A lot of the fire was on these mountains. You gotta imagine, these are very steep mountains. And in the springtime, these are very lush and green. And because these mountains, these forests were also used for logging, sometimes they are, this is green, this is going to be brown because of logging. British Columbia said, we lost our logging land. You burned down our forest because, and can't sell it for logging rights anymore. We also lost our green looking wonderful mountains. Court sided with BC first. FARE1040 appealed, took it all the way to Supreme Court. Supreme Court, they said, hey, let's look at the evidence. Let's look at what the expert witnesses said. These mountains where the fires started, they were way too steep for logging. So you can't claim damages to your logging business because it was impossible to log those mountains anyway. So they bought the expert witness in that instance. And then when it came to the environmental defense, they said, you guys never actually gave any evidence. You never estimated any environmental damages. You didn't have an expert witness to say how much environmental damages. The previous court just arbitrarily decided 1/3 of the value of the logging rights should go to environmental damages. That's not scientific. That's pretty arbitrary. So that was also struck down. Because the British Columbia government had bad expert witnesses, the company set half the mountain on fire and got away with it. Competence is important. Talk about Smith versus Inco. Smith was a little old lady who had a property in Port Coburn, Ontario, and Inco is a nickel refinery. And this was a class action lawsuit, and Ms. Smith was the representative person representing the entire the neighborhood, who said that Inco has been contaminating our land with their nickel contamination, whatever, and we want damages, their health effects, all this stuff. They take it to trial. Their evidence for Smith and the other residents was, look, the Ministry of Environment says only the safe level of nickel in the soil is 200 parts per million. And here in our land, we have 9,000 parts per million. Obviously, this is contamination. Inco came back and said, yes, it's true that the Ministry of Environment says 200 parts per million is the safe standard. But it's not the safety standard for humans. It's the safety standard for some random plant. Smith and friends couldn't establish what is the safe contamination level of nickel in the environment to talk about health effects. So they lost that count. They were relying too much on the Ministry of Environment giving them the correct estimate. But the Ministry of Environment never tested for what's safe for humans. The Smith and friends also complained that the existence of this mine is causing our property values to go down. Because look, next door to Port Colborne is Welland. Property values go up faster there than they do in Port Colborne. Inco brought on some economists and said, yes, it's true. Welland has higher prices, and they're appreciating faster than Port Colborne. But there's no reason to believe that it's because of this nickel contamination, because the nickel, as we just proved, isn't contaminated. We don't know what the safe nickel standard is. So because there's no safe nickel standard, we have no idea. It's not a basis for not valuing property based on too much nickel. We have no idea what too much nickel is. We know what too much nickel for some random plants are, but not for some people. Because of this, Inco won. And they got to keep refining nickel, and Smith and her friends, they lost out. So that's all I wanted to talk about today regarding this. Any questions on the role of expert witnesses? So next week is the reading week. I'm going to be putting up the quiz this Sunday, but you will have an extra week to do it. Yes?
Is there any way to post like the graded versions of last week's quiz? You can see what questions you got wrong.
No. I mean, there is, but I'm not going to do it.
So we can go with
Yes. If you want to know what mistakes you made, come to office hours.